Everyone, we're ready now to return to State of Tennessee versus Joel Guy. Do we have any preliminary matters we need to address before?
Yes, Your Honor. I think I told you I was going to prepare a stipulation. The general is approved and signed. I can approach.
We're going to present this during defense brief.
Yes.
Very good.
And
What
I
else?
have one other matter.
All right.
Dan Boudreaux came through for us, Judge, and yesterday afternoon while we were in court, we have sent in an affidavit, so I would just attach this to the affidavit.
Let's make it ID only since it wasn't, or you want to present it to the jury?
No, I'm not going to talk about the business records affidavit.
Okay.
Just to support the
Yeah, that's true.
base hardware reporting.
I've lost my numbering, so I don't remember which one that is, but just, we can just add it to it. We had,
I said yesterday that I expected it to be coming
Thanks.
in, and it did. So
yeah, okay. This is 701B. All right, anything else, General? All right. Is Dr. Marks here?
Yes, he is. But we've got one real quick witness before him.
Okay. Are you ready for the jury?
Yes.
Okay, bring him in. Are you serious? Sure is. We've lost audio, folks. Give me just a minute. Yeah, I don't even have any control up here. No, it just came back. Test. Are you working?
We got the 701 on that.
Okay. Do what? Oh, you can if you need to. On that affidavit, you mean? Yeah. Well, that one we can redo later if we need to. Please rise for our jury. Thanks, Kristen. All right, everyone, you may be seated. Does the state waive the call, jury? Defense waive the call?
Yes, Your Honor.
Welcome back, folks. We are ready now to resume the state's case in chief. General, please call your next witness. Can we ask Mr. Brink to step in, please? I don't think your victim witness coordinator's in here right now. Sir, if you please just come up here to the witness stand next to me. If you please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in the case now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat, sir, and once you're seated, you may remove your mask to testify.
And sir, if you put the microphone close to your mouth, please. If you tell us your name, sir,
Jim Brink,
and by whom are you employed,
Kgis.
and what does KGIS stand for?
It stands for Knoxville and Knox County, KUB, Geographic Information Systems.
If you would, explain to the members of the jury some of the duties and responsibilities you have working for KGIS.
Well, we do maps for the county, the city, and KUB, and any of those entities, fire, police, whoever that needs maps, and also web development.
Okay. And are you aware whether or not KGIS was contacted in this case to create 4 maps?
Yes,
And have you had a chance to review those maps prior to testifying today, sir?
yes, I have.
Yes, sir.
So I'm going to show you what's been pre-marked as States Exhibits 744, 45, 46, 47, and ask if you can identify those documents, sir.
Yes, they're maps that KGIS has done.
Okay, and if you would, tell us what the first map is, sir.
The map is the location.
That microphone over close to there, thank you.
The first one, it shows the location of 11434 Golden View Lane.
Is that an aerial version?
It's an aerial view with the outline of the parcel boundary.
Okay, and the next photo, sir?
The next photo is a map that shows the aerial photo around Turkey Creek area, and it shows from the interstate level road to the residence at 11434 Golden View Lane.
Okay, and the next document?
The next document shows from Knoxville, Tennessee, the route to Louisiana, to Baton Rouge.
What's the mileage between, sir?
The mileage is 642 miles.
And the last document?
And the last document shows Turkey Creek aerial photo, and it shows Walmart highlighted and also PetSmart highlighted.
And is there anything else highlighted on that map, sir?
Yeah, also up in the upper left corner is the residence at 11434 Golden View Lane.
Now, at this point, we move in States Exhibits 744 through 747,
Any objection? 744 through 747.
and ask to publish if we could.
Thank you very much.
Mr. Brink, directing your attention to the overhead board, sir, could you tell us what we're looking at?
Yeah, this is the map from Turkey Creek. So the blue line shows from like Turkey Creek Level Road Interstate all the way to the residence of 11434 Golden View Lane. And that's an aerial photo with streets and buildings.
The next document, sir?
This shows the route from Knoxville to Baton Rouge, and that is 642 miles.
And the last document?
So this one shows the Turkey Creek area. The orange is around Walmart. The purple is around PetSmart. And then in the upper left, the red is the parcel for the 11434 Golden View Lane residence.
And if you could, with your finger, draw a circle around the residence. So I'm gonna approach with what's been pre-marked as State's Exhibit 748, 749, and 750, and I'll ask you if this accurately depicts, or is a blown-up version of one of the maps that we've already looked at.
Yes, it does.
With respect to Exhibit 749, sir, I'd ask you if this is a blown-up version of a map that we've looked at.
Yes.
And with respect to Exhibit 750, sir, I'd ask you if this is a blown-up map of the map that we looked at.
Yes, it is.
Your Honor, we'd move these in as State's Exhibits 747, 48, 49, and 750.
In objection. 748, 749, 750.
We pass it.
Cross-examination. Thank you, sir. You may sit down and review. All right, next witness.
Dr. Murray Marks.
Christy, do you have the lapel mics? Maybe Jennifer grabbed it. Doctor, if you please raise your right hand. Do you solemnly swear or affirm the testimony about to give in the case now on trial be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat, Dr. Marks. Once you're seated, you may remove your mask. We've disinfected the chair for you there.
Could you state your name for the record, please?
Murray Marks,
Dr. Marks, where are you employed?
at two places, the University of Tennessee Graduate School of Medicine and at the Regional Forensic Center in Knoxville.
What is your occupation?
I'm a forensic anthropologist.
Can you describe for the jury, please, what a forensic anthropologist does?
A forensic anthropologist in the working for the medical examiner's office really does two things. They look at skeletal remains, decomposed remains, mutilated remains, and help the medical examiner determine age, ancestry, gender, stature. They provide a biological profile of an unknown individual. The other thing they do is look at trauma, blunt force, ballistic force, sharp force trauma to bone. In essence, the anthropologist answers the questions posed by the pathologist.
Okay. Can you discuss your educational background with the jury, please?
I have a bachelor's degree, a master's degree, and a PhD. The PhD was from here at the University of Tennessee. Returned after I got my doctorate to be a forensic anthropologist, became board certified, which is kind of the final hurdle you do academically and professionally.
All right. And just a brief background of your employment. Where have you worked?
Where have I worked? Strictly for the Graduate School of Medicine as a professor in forensic dentistry. Before that, I was a faculty member in the Department of Anthropology here at the university. The forensic work has been primarily for the Regional Forensic Center here in Knoxville, also the forensic anthropologist for Chattanooga, Hamilton County, and do a variety of lectures and courses for the University of Western Australia and Boston University.
Are you published in the field of forensic anthropology?
Yes, ma'am.
And did you prepare a CV for purposes of your testimony today?
I did.
May I approach the witness?
You may.
I'll show you what's been marked for identification as Exhibit 751 and ask you if this is your CV.
Yes, it is.
Okay, thank you. We would ask Your Honor, please, to introduce this into evidence.
Any objection? Exhibit 751.
At this time, Your Honor, please, we would tender Dr. Marks as an expert witness in the field of forensic anthropology.
Any objection? All right, folks, the court is going to recognize Dr. Marks as an expert in the area of forensic anthropology. Once again, since he's deemed to be an expert, he's allowed to render his opinion within his area of expertise. Also, once again, just because an expert witness has rendered their opinion does not mean that you are bound to accept it. It's your job to judge the weight and credibility to be given to his testimony, just like every other witness. But he is an expert, so he may tender his opinion. You may continue.
Thank you. Dr. Marks, did you participate in an evaluation and examination of the remains of Joel Guy Sr. and Lisa Guy?
I did.
Can you tell the jury how you became involved in the case?
I became involved because the forensic pathologist, Dr. Hawes, asked me to participate and look at the remains and make an assessment of skeletal trauma.
And did you determine, were you able to identify the remains?
Yes.
With respect to Joel Guy Sr., how was he identified?
He was actually identified by fingerprints, so I didn't have anything to do with that, but I was cognizant of that.
Did you review dental remains
I
for
did.
him as well?
I did. Teeth being part of the skeleton, I also review those, look at that, and in case dental records come in on that person, then we can make those comparisons with the help of a dentist. But since there was fingerprint material to use, that's how he was identified.
Were you also able to make an identification of the remains of Lisa Guy?
Again, looked at her dentition and prepared things for that, but she was identified from an orthopedic appliance, so we didn't have to do a dental ID on her.
All right. Did you prepare reports regarding your evaluations of the remains of Joel and Lisa Guy?
I did.
And I would just ask you if we could just begin with Joel Guy Sr., and if you could discuss your findings in your report. If you, and just for a little background, explain to the jury what your process was once the remains come into your possession. What did you do with them?
When they come into the medical examiner's office, they're photographed and everything's documented. When the pathologist finishes his or her autopsy, then the anthropologist can step in and do whatever they need to do to answer the question, in this particular case, about identification and trauma. Because identification, I don't believe when I was first introduced to the case, was made at that time. But that became apparent who these individuals were. And so the next thing is to look at the bone. And the pathologist said, can you tell me about any damage or what's the status of the skeletal remains of both these individuals? So to do that, removed what soft tissue was in the way of looking at the bone, which is a good majority of it. And then again, prepared this. Took a good bit of time because there was no scalpels used or anything like that. So have to slowly tease away the muscle, the soft tissue, and the periosteal or the covering on the bone surfaces to look at any damage. So again, you're talking about several hours to actually prepare the remains to look primarily at the skeleton.
And with respect to Joel Guy, could you discuss the results that you derived from your examination of his remains?
There's, excuse me, there's two events that take place to the skeleton, in my estimate. First have to do with trauma that occurred around the time of death, what we call acute or perimortem. And then there's a type of trauma that is postmortem. And so I broke down my report based on these two types of wounds. The wounds, and this is all sharp wounds, There was a few bone breaks that would have been caused by blunt force, but that was probably associated with the sharp force trauma that took place. There was no ballistic wounds or gunshot wounds or anything like that. So in looking at the remains, the first thing I noticed was the sharp force wounds. And the sharp force wounds, particularly that had to do with around the time of death, were primarily to the ribs. There were 6 right ribs and 6 left ribs that had at least 16 cut marks on them, or slices. These wounds were everything from a kind of a grazing line to a somewhat deep incision to a complete severing. There was also chipping of the bone. Sharp force trauma to bone involves, bone is a fragile tissue, and so up against a sharp implement, whether that's a bullet or a baseball bat or a knife proper or a saw or something of that, will tend to splinter and chip, and you can get an idea about what bone is doing based on those wounds. So to that end, notice that these wounds had to do with, for the most part, trauma, particularly to, like I say, the rib cage. There were 6 right ribs, 6 left ribs, and then some trauma to the right scapula or shoulder blade. So all total, there were at least 16 wounds to the rib cage. And again, these slices were of all varying degrees, complete severing of the rib to chipping and that type of thing. So, and there's pictures in the report of that. The second...
I'm sorry.
I'm sorry.
Go on.
Go ahead?
Yes.
Okay. So the rib trauma did not have to do with the taking apart of the skeleton. The rib trauma was primarily in the back area, and in looking at that trauma, there was no attempt to take apart ribs or take apart vertebra. So the idea is that, that's probably something that happened around the time of death compared to afterwards. Then there is probably what I referred to as a post-mortem event where the body was disarticulated or dismembered. Those two terms are kind of used interchangeably. The arms were removed from the torso at the joints, okay, so at the shoulder region. The hands were removed from the forearms or the lower arms below the elbows, again at the wrist joints. The legs were removed from the torso at the hip joints, and the right foot was removed from the ankle joint. This was definitely a post-mortem type of an event. There was a solution involved. I was told, I did not visit the scene. There was a solution involved that the remains were in upon discovery, and that really damaged the bone. So exposed bone surfaces, particularly when the arms and legs were removed, wrist removed, foot removed, those bone surfaces started to be denuded or destroyed. So there would be incised lines that were very hard to read in those particular areas. The skull and the mandible didn't show any type of sharp force injury.
Okay. Would, as part of your report with respect to Mr. Guy, there were diagrams that you prepared, is that correct?
Yes, ma'am.
And would that assist you in illustrating for the jury the injuries that you noted and referenced in your report?
Sure, yes. Okay.
If you want any of these tools, they're right there.
Okay.
Yeah, there's a stylus there.
Okay. Okay.
did you read the findings that you made with respect to the top portion of this page?
Excuse me. The top image shows the ribs after I remove them from the soft tissue and the vertebral column. What the image represents is the ribs laid out in anatomical order. So you always display things as if someone is looking at you. So the ribs on your left are the Mr. Guy's right ribs, and the ribs on the left are his well, he seems, the ones on the right are his left ribs, and the ones on the left are his right. So it's difficult to see, but there are red dots that are on the bones, and those red dots are in places here, 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 here. And these areas represent sharp force injury on the bone. And probably some other places as well. Those are areas where there are sharp force injuries to the ribs, and they represent, again, areas that are damaged. Down towards the bottom of that image, the cut-off pieces were performed at autopsy. That's part of the procedure to look at the organs. So the ribs are cut down towards, and that would be the front part of the chest area, so that the organs can be removed. So that has nothing to do with the report as far as trauma is concerned. But what that represents is the area primarily in the back region that received sharp force trauma. The image below is a computer-generated picture of the chest region from the front view on the left and the back region on the right. And what it represents, again, are areas where there are cuts. So to look at that, there's sharp force trauma in the areas that are red. So here, 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 here. Again, that you can see on by looking at it from the front. When you look at it from the back, which is what this picture shows, it demonstrates other areas of trauma that are primarily in the back region. So you can kind of see, and they're all in the back. As I said, you're just looking through on the image of the right. So this, again, is just a computer-generated picture that shows where there's sharp force trauma to ribs.
So do any of these diagrams illustrate fractures to the ribs?
Not so much on these. The fractures to the ribs would be up in here in the first image. There's some breaks up in here. There might have, I think there was another one over here. Now, by fracture, do you mean a complete slice, or do you mean a blunt force?
Either, if you could describe the difference.
Okay, well, the blunt force would be from associated with a fracture line, which is part of pushing and then eventually breaking. So, yeah, there's a few of those as well.
I'm going to move on to the third page of the report and ask you if you could discuss what these images depict.
Okay, so what these images show, starting at the top left, that's the right fifth rib, then the top right is the right sixth rib, and then the right sixth rib are the middle two pictures. The right seventh rib is the bottom two pictures. So what I did was I selected certain ribs that were characteristic of the different types of trauma. So in starting at the top, what we have, what the arrows represent, and they're somewhat difficult to see, but there's an arrow here and an arrow here and one in the middle. And those three arrows show two different types of damage to the ribs. The ones on the periphery or lateral demonstrate breaks or scrapes where a piece of bone was popped away. The one in the middle is like a cut. So it has a cut with several linear lines to it. But again, talking about the superior border. The other is the right sixth rib, and this is a slice that is somewhat deeper, and it has a piece of bone that is actually pushed up. So what it means is that the weapon kind of twisted or caused the piece of bone to work its way up. The middle two pictures demonstrate a complete popped out region, meaning there's sharp force trauma along the edges, and then the central region has been removed because as the blade was lifted or moved or twisted, a piece popped away. And the other image here is just a superior view of that, showing the region of damage. At the bottom, we see some superficial nicks, but again, many of them that demonstrate a variety of different depths, again, on the superior border of the rib. The area, excuse me, the image on the right shows complete severing of the rib from where it was embedded into the vertebra. So every rib is embedded in the vertebra, and that shows where there's been a complete slice that has separated the rib. Okay, so the picture at the top is the right 8th rib. The picture at top left, top right is the right 9th rib. And then the middle pictures are the left 7th rib. The picture on the right is the left 10th rib. Okay, so looking at those four, again, what they're demonstrating is a variety of cuts. So in looking at this, we see a cut in this region, and then turned on end, a different rib, we see a slice that goes down, a little bit deeper. Okay, but they both show kind of where you have sharp force and then a kind of a moving away of the bone. I guess a good analogy might be a frozen stick of butter and how you stick a knife through it in pieces. If it's frozen, pieces will pop away or will move accordingly. Bone's a little bit more of a complex tissue than that. The two middle pieces kind of show the same thing at different angles, an uplifted piece of bone, and then a complete wedge of bone that has been removed. Again, the whole idea was to document the different types of sharp force trauma that impacted the ribs in the whole instance. The bottom three images demonstrate the 11th rib, and what they show is breakage. There's a slice in this region here, and then there's another slice over here, but they represent two views of breakage that happened, which is what this represents, and of course all of this. That was associated with, again, pushing or pressure against a cut area that caused fracture to the rib. And then the image at the bottom, this is a close-up of this region here, which shows the cut and the break. Page 5 just simply shows these two images don't really have anything to do with trauma. This is a healed fracture callus of a fracture that took place months or years before, but I included it in there because of the time element, not really knowing for sure what was associated, and the pathologist wants everything documented. So these have nothing to do with sharp force trauma. They're a fracture callus from a previous break. So the images at the bottom represent the scapula, and here you're looking at, this is looking at it from the back, and this is looking at it from the inside, or looking through the rib cage. And what this perforation represents on both sides is a puncture of blunt instrument, if you will. Not so much sharp. There could have been a sharp component to it, as we'll see, but the piece was found. Again, it's a puncture wound from the back, which is what this image represents, from the back, going in here, and the piece was broken off and found in the musculature on the inside of the scapula. Right, this was the piece that was found embedded in the musculature. Not a sharp implement at all. This edge is not sharp. It might look like it. The only thing I could think, a lot like a letter opener, right? And some of those can be sharp, but sometimes they're blunt as well. So, again, something that punctured in and was broken off, but not really had a slice or an incised line to it.
Does that indicate to you that more than one weapon was used?
Yes.
Anything else on this page?
Oh, okay. So the bottom image shows the right and left humerus, and what these represent are changes in the areas up near the shoulder region. So the elbow region would be down here, and this is the shoulder, and what this represents is complete denuding or breaking away or dissolving of that proximal part of the bone. So the head of the humerus, which is the upper arm bone, both of these instances is gone. It's been somewhat dissolved. There's a little bit of a remnant of sharp force injury that can be seen over here in this image. This image is a blow-up of the humerus on this side, and you can see some very faint striations or cut marks, which would be associated with severing of the top of the shoulder. All right, so this shows the femurs. So again, what we have here is the left and right femur heads, and what the arrows represent in this area here, that you can see these small arrows represent areas where there's cut mark striations around the neck of the femur head. Of course, this is what fits into the pelvis region, and you can see there's breakage in this area here. You can see some cut mark regions here that are associated with, damage from sharp force injury. When we look at the left femur, this was the right femur on this side. When we look at the left femur, we're looking at the back of it, and you can see that the head has been completely removed. So there isn't any femur head. That was actually found lodged still within the pelvis region. So the neck of the femur was cut off. The femur is the upper leg bone, or the bone that is inside all the thigh musculature. Yeah. The two images at the bottom, they represent, okay, these are the elbow regions, and these are what fit into the humerus. Okay, so they're unaffected. They don't have any cuts or scars on them. But what it shows is the degreasing, if you will, that the chemical caused on this part. So the wrist regions would be at the ends where they attach. No evidence of particularly cutting in those regions on the bone because of the damage that the chemical caused to the bone surfaces. Yeah, the skull didn't have any type of sharp force trauma. It didn't have any type of blunt force trauma as well. But the central region was completely gone. So from the middle part of the forehead down to the left part of the maxilla or upper jaw, this was all missing. And the surfaces, the borders, were all damaged from the chemical exposure. So there was no evidence of sharp force trauma to any of that. The dental inventory simply, again, the teeth are part of the skeleton, and so the anthropologist documents them as well. Once identification was made from the fingerprints, it didn't have anything to do with identification. And the jaws were completely unremarkable with respect to trauma. There was no sharp force or any other type of trauma to that region. So the conclusion, if you can read that, mentions that, the skeletal remains were dissected from the soft tissue after autopsy to do what the pathologist asked, to look for and kind of interpret the perimortem or postmortem around the time of death or after death, sharp force injuries. And so both the dorsal region or the back part of the ribs near the vertebral column showed sharp force injuries that ranged from very fine lines to scrapes to regions popped out to complete severing of the bone that had to do with a sharp implement. The wound that had to do with the scapula was somewhat more blunt because, again, it didn't have a sharp edge to it. I believe that's it.
Any objection? Exhibit 752.
I wanted to know if you would be, you could explain to the jury the difference between dismemberment and disarticulation.
Okay.
I'm
sorry.
I didn't know if you're going to have him step down or not. I was going to try to get a lapel mic. Christy, do we have those lapel mics in here?
I can scream if you want me to.
Well, I might need to, but let's try this first before you scream.
You want me to come down here?
Yes, please.
Okay.
And I hate to do this to you, Doctor, but since you're not behind the glass, the Supreme Court makes me tell you where you're at. So thank you, sir. I appreciate that.
Okay, so your question about dismemberment or disarticulation. The two terms are used interchangeably. It's like grandma and grandmother. They mean the same thing. It's just sometimes when you talk about disarticulation, anatomists and people that are, describing things will talk about where the joints are. This is where the bones articulate. So disarticulation means the taking apart of a skeleton at the joint areas, whether that's in the skull, the hip, the knee, ankle, wrist, elbow, or shoulder. You can disarticulate the vertebra between, because there's a disc between, so that's the term disarticulation, and I use them interchangeably with dismemberment. Dismemberment is more of a broader term, which means just, I'm going to break this thing up or saw it up or do whatever I'm going to do, and without any respect to the joints. So that's kind of the differences between the two. And anthropologists will use both terms interchangeably. Disarticulation is a little bit more specific. Disarticulation is also dismemberment in a way. Dismemberment, though, is just simply breaking something up. Does that help?
Yes.
Okay.
So if you would, just show the jury where Mr. Guy's limbs were disarticulated.
Okay. Both shoulder regions, and they were unattached. Okay. So again, not being able to see cut marks except on those real fine lines of that bone that had been dissolved a little bit at the shoulder regions and at the wrist. Okay, and then at the hip joints. Okay, they were taken apart, and at the knee joints, and the right ankle was taken apart. So that was the disarticulation process.
And the ribs that were damaged, 6 on the right and 6 on the left, is that correct?
Right, and so what you would do would be to look at it this way and count them down. I'd have to look at my notes to know exactly which ones they were. The wounds were associated primarily with where they articulate with the spine about a third of the way over. Again, there was damage to the scapula, which would have been in the way of covering the ribs, a certain part of it, then all the way down. So again, no damage really to the front.
Okay. And the skull, where did you detect damage to the skull?
The damage to the skull was in the facial region. So it would have been the area right in the middle. So it was dissolved, the bone was dissolved. The small bones of the internal face were gone. The frontal region was missing, the nasal region was missing, and one side, I think the left side of the maxilla was loose. So that was kind of the area that was damaged.
Okay, so you weren't able to tell if there was blunt force trauma there or sharp force injury?
No, ma'am.
Okay. Did you detect any indication of the type of weapon maybe that was used? Were there saw marks? Or-
There was no saw marks, so there was nothing that was associated with chopping or sawing.
Could these sharp force injuries have been inflicted with any type of knife? I mean, do you have an opinion?
Oh, yes, definitely. I mean, I'm not sure what other sharp force injuries, those types of injuries I've seen before have always been associated with it. Research that anthropologists have done, graduate students, publications have used implements like that to produce wounds in bone that are synonymous with what I saw.
Can you disarticulate limbs with a knife? I mean,
Oh, yes. Yeah. I mean, if you have the patience and the perseverance, I mean, it takes time to cut through the ligaments, the muscles, the joint capsules. I mean, it's a lot of work to disarticulate a body at the joint surfaces. Yeah. But it could be done with a knife.
Now, with respect to, let's turn to Lisa Guy, and I would like to do sort of the same thing. This time I'll ask you if you prepared a report with respect to your findings on Mrs. Guy. And again, how identified?
I think she was identified by a orthopedic appliance.
Okay. And if you could just describe your observations of her remains.
Well, her, again, pretty much a lot like his. The head was separate, so there was a little bit of a different type of decomposition or chemical altering of the remains because it was a separate piece. But for the most part, the damage to the soft tissue, again, which is not my area of expertise, was pretty similar. So the damage to the bones was identical.
Okay. And what were the results of your examination?
Looking at, again, everything after it was processed, after all the bones were available for study, the head was removed prior to discovery of the scene between the second and third cervical vertebra. Okay, there's a disc space between every vertebra, and the slicing was between that. The arms were removed at the shoulders. The right hand was removed at the wrist. There were sharp force wounds to 21 ribs. 21 ribs had sharp force injuries, kind of the same as I've described. There was also trauma to the scapula, with shoulder blades, both left and right humerus, or the upper arms, the radius and ulna of the lower arms, the cervical vertebra, and again, the ribs. So there were left ribs that had 9 damaged. There were 12 right ribs that were damaged, and these ran the same type of a degree of severity, from very fine incised lines to chips and wedges and complete severing, or complete perforation. The right scapula had 9 wounds that were associated with disarticulation. They are at the joint region. The left scapula had 1 that had that damage to it. The tibia and the fibula, or the lower legs, didn't have any cut marks on them because of the chemical exposure.
Showing you what's been marked for ideas 753. This is the same report that you're discussing at this point.
Yes, it is.
So we formally move this into evidence, Judge, and I would ask to publish some of the photographs, not photographs, but diagrams from the report.
Any objection? It'd be Exhibit 753, you may publish.
So on page 2 of your report, pages
Okay, well, this is the same format that I used in the other report, again showing the ribs. And the ribs are not completely cleaned, all the way down to the bone surfaces, particularly where they articulate with the vertebra. Special care had to be taken not to obliterate anything, so that's why they can kind of look a little fuzzy. But in the same respect, what we have are these red dots that are associated with cut marks on the ribs or areas where that took place. So, and I might be missing some because they're kind of hard to see at places. But those are the areas where, I've got one here as well, or here. Those are the places where there were sharp force trauma injury to the ribs. The picture at the bottom, again, the same computer-generated image. It's not the decedent. It came from a web-based source. And what it represents, again, where the red areas are wounds to the ribs. And again, these are all on the back side. Okay, here and here. When we look at the back side, which is the image on the right, you can see more of them, all this area here. The green areas that you can see here are fracture calluses that were broken prior to death. Old injuries, yes. So, again, these are micrographs, again, taken at about 6 to 20 power. The same with the Mr. Guy's images that were taken, and they show the rib areas and the cuts. We have the left first rib, the left second rib on the right, left first rib on the left second rib on the right. And then at the bottom, the left third rib and the right second rib. Again, the idea was to show or document the different degree of cutting, from a partial slice like we see here, a slice here, but also all these little chatter marks that it's called when a blade goes in and moves back and forth. Sometimes it leaves a chatter mark on bone. The image down here shows, the arrow shows a bent area where if the blade goes in and twists, then the bone gets bent down, so you can get an idea about angulation. The image over here just simply shows a grazing line or an incised line. These images, the two at the top are the right seventh rib, and then we have the right third rib in the lower left and the right 12th rib in the lower right. And what they represent, again, are two types of wounds: a complete severing of the rib and a notch. So different types of wounds. Again, what this shows here is a little bit of the bone that's been turned up because of the pressure as the blade twisted or moved. The image at the bottom, the lower left-hand corner, shows again complete breakage of the rib, but it also shows this area here that is a popped off or broken region. Again, putting something in or putting a blade in and then twisting it can pop off a variety of regions. The other image just shows breakage from force, from pressure. That's not a cut mark thing, but that's from a wound that's associated with pushing. Blunt force. This is the left fourth rib of the decedent, and what it represents is, again, this combination of a sharp force injury that you can see here, and then a region that has been popped out or removed by virtue of that. Again, a blade twisting can do a variety of things, from the little chatter marks I mentioned to an incised line, to complete severing, to the whole aspect of popping out a piece. The image at the bottom shows the scapula. And what this represents, you're looking at the back side, and what this shows are areas where there's sharp force trauma. Actually, another one here. This is cut here, region cut there, and also there. So different areas where there's sharp force trauma to the scapula that, you know, if we would separate this down the middle, the areas to this side associated with the vertebral column are probably associated with rib wounds, whereas the areas on the other side, the shoulder area, are probably more associated with disarticulation.
Okay, so on the left-hand side, those
That's,
marks are associated with the sharp force injury, and on the right, the disarticulation.
yes,
Removal of the
yes, exactly.
area.
Oh, thank you.
Next page.
Okay, this shows the scapula, the right scapula, and it shows two regions of that. What this shows is just simply a wedge taken out of the bottom of where your upper arm fits in and rotates. So the scapula goes down in the back, and so right underneath where this is, close to the armpit. This other area shows a cut region that is on the front part of the scapula and kind of the front of the shoulder region here, and that's been completely severed. The picture at the bottom shows the left scapula, and what it shows is this region here where the acromion piece, or the part that you can feel on the back, the ridge you can feel on your back going towards your shoulder, has been severed.
This next page.
Okay, these four images demonstrate the changes that took place because of the chemical solution. So again, we have this picture here that is the upper arm bones, or the humerus. So the shoulder regions are at the top, and what they represent is chemical destruction. There's also destruction in this region of the elbow, but it's not from dismemberment or disarticulation. That area is very close to the skin surface. And so if that skin is gone or moved away or damaged, then that bone can be vulnerable as well. The forearm bones, this would be the right forearm, or the area between the elbow and the wrist, and this is the left. This shows that the damage and denuding or chemical change of the wrist region. And the left forearm bones, here and here, show that really to an extreme degree. The pictures at the bottom demonstrate the changes in the knee region that goes down to the lower leg. So this is the knee region, this is the ankle region, and you can see that the knee regions on both sides have been denuded by a chemical exposure. And the lower right ankle shows that change as well.
The next page of the report, we're not going to do photographs of this guy's skull, but I would ask you to just describe your findings with respect to her cervical spine and skull.
Okay, so this is the first cervical vertebra, called the atlas. This is the second cervical vertebra, called the axis, atlas and axis. And what this represents, or what this shows, is breakage of these areas here. And so on the side of the vertebra, that's where we have blood vessels, and those have been broken. They've not been cut. So it's a blunt force trauma in that region. If we look on the bottom of that vertebra, again, our atlas, or our first cervical vertebra, where it articulates with the skull, you can see that this area has been chipped or damaged compared to the rest of it. And that's from forceful movement back and forth of the vertebral column against the skull. What this image over here represents is the part of the second cervical vertebra, way up high in the neck, that sticks out. So this would be the back part, and this would be more of where the spinal cord is, and what it shows is sharp force trauma. The white circles demonstrate two areas of sharp force trauma or slicing.
So does this mean that, when you talk about movement and blunt force, does this mean that, that her head was manipulated or moved with blunt force
Probably so, yes, yeah.
before it was disarticulated?
Well, it was probably part of the same process.
And your conclusion?
So she received 21 sharp force injuries to the ribs, 12 on the left and 9 on the right. There was a close look at those surfaces, looking at the bone and how it's bent. You can get a direction of force that came from the back and from the top by looking at those wedges and how they're turned and bent. Like I say, you can make an assessment of that. And so out of those rib wounds, there were 3 nicks, 9 slices, and 9 completely severed ribs. Yeah, and then the first cervical vertebra had that blunt force trauma to the transverse regions that had to do with, again, trying to manipulate or kind of move the head, but there was also slicing as well on that second cervical vertebra.
Dr. Marks, I'm going to ask you to step down again and use the model to describe where you observed injury to Lisa Guy's remains.
Okay, well, again, what we have is dismemberment that was not at the hips, but just in the knee region, and one ankle or one foot was removed. So the hip region was intact. The wrists, there was probably severing there, probably removed, but again, chemical decomposition of the ends of those bones, as you saw, prevented looking at any cut marks. So there was no sharp force trauma in those particular regions. The elbows were preserved, but we have changes again, or disarticulation at the shoulder region, which is associated with those wounds to the scapula, the notches and cuts we saw on there. The head was removed way up at the top, which would be actually between the second and third cervical vertebra, but there were also cuts to, again, the bottom of that second cervical vertebra. The damage to the atlas, or the top cervical vertebra, is associated with, again, movement of the skull.
Very well. And all of your findings were to a reasonable degree of scientific certainty, is that?
Yes, ma'am.
Is there anything else that you can add to regarding your findings?
No, I don't believe so.
I'll ask you the same question. Do you believe that just a knife would, or maybe even more than one knife, could have inflicted these injuries,
Yes, ma'am.
including the disarticulation?
Yes, ma'am.
Okay. And Mrs. Guy's right hand was separated from her arm, correct?
Mm-hmm.
Okay. If I could have just a second, Your Honor. think that's all that I have. Thank you very much.
Cross-examination?
No questions, Your Honor.
Thank you, Doctor. You may sit down. You're free to go. Have a good day. Yeah, that's fine. Thank you. All right, any further proof from the state?
Please, the state of Tennessee rests the case.
All right, ladies and gentlemen of the jury, the state has now rested its case in chief. That does not necessarily mean that you have heard all the evidence that will be presented to you to decide this case. The defendant has no burden of proof in this case, but he is given an opportunity to present evidence to witnesses and exhibits if he wishes to do so. At this point of the trial, I always have to take a break to deal with certain legal issues. When we come back, we will do one of two things. If there will be any defense proof, we will hear that. If they choose not to present any proof, then we'll go into closing arguments. Once again, do not discuss this case among yourselves or with anyone else. You can leave your notebooks in your chairs. This break always takes a while. It'll be at least 20 minutes, probably more like 30. So leave your notebooks in chairs. Go with the officers. I'll see you here a little bit later.
Yes, there is, Your Honor. We would move for a judgment of acquittal, alleging that the proof is insufficient to prove that it was Joel Guy who had committed these crimes, specifically as to counts 4 and 5, charging felony murder during the perpetration of a theft. It looks like the only thing that they're alleging is that perhaps he had made credit card transactions. Even the evidence on that wasn't very strong, but that he had made credit card transactions. That is not a theft. That is fraudulent use of a credit card. So the way that he is indicted, we believe, is insufficient to prove felony murder by theft, counts 4 and 5. Counts 6 and 7, abuse of a corpse, the state has not met their burden that this was without legal privilege. They have not shown what the legal standards are or that this was in violation of those. So we believe that they have not met their burden on count 6 and 7.
Thank you, sir. General, your response
With
as to...
respect to the felony murder counts, we believe that it is properly charged, Your Honor. Please, I would further point out that the property of Joel and Lisa Guy was found in the defendant's the room where he was staying, their medications, and other articles. So that's all I have to say on that point. With respect to the abuse of corpse argument, I just, absolutely disagree with Mr. Halstead's characterization of the state's proof on that.
All right, thank you. All right, when the defense makes a motion for judgment of acquittal under Rule 29 of Tennessee Rules of Criminal Procedure, the court has to look at the evidence that has been presented up to that point in the light most favorable to the state and draw any rational and reasonable inferences in favor of the state's theory of the case. If after doing so, the court cannot determine that the state has met its burden and shown that each element has been proven from the evidence presented, then the court would enter a judgment of acquittal as to that particular count or counts. In this particular indictment, we have 2 counts of first-degree murder, counts 1 and 2. The issue that the defense has argued is the identity of the defendant as a person who has committed those offenses. I don't need to recite all the evidence has been presented, but there has certainly been a very significant amount pointing to the defendant as the person who perpetrated these offenses, including his blood and DNA left on the weapons that were there at the scene where the bodies received sharp force injuries. There's a lot more circumstantial evidence than just that, but I think that's sufficient alone to get past the judgment of acquittal. And so I'm not going to summarize everything else, but we'll just leave it at that. Regarding the felony murder counts having to do with allegations of theft, there is circumstantial evidence of property belonging to Joel Guy Sr. and Lisa Guy being in that room. That's not the strongest argument. I also think that the use of funds to make purchases on their credit cards, that could be fraudulent use of a credit card. It can also be theft. It would qualify under the elements of theft as well, I believe. And so not only the credit cards, but other property, I think, gets past the judgment of acquittal motion. As to abuse of corpse, the showing whether or not there's a legal standard, the court will instruct the jury regarding the elements of the offense, and I don't know that the state has to prove something that I think kind of comes with common sense, and that is a general member of the public cannot just dismember bodies in a community. And so to me, that's not really an issue. I guess there could be proof, even though the defendant has no burden of proof, that he did have some legal privilege to do this, but I don't think that the state has to bring forward proof showing that Mr. Guy is not a mortician or was working any type of duties pursuant to state statute. So I do think the state has met its burden at this point and will deny the motion for judgment acquittal as to all 7 counts. All right, we do have a 608 notice that's been filed. There's no 609. There's no prior convictions. The state is seeking to impeach Mr. Guy should he testify. I have reviewed the 608 notice regarding specific instances of conduct. I'm going to go through those real quick and give you my ruling before we do Moman. The first one is the state would like to cross-examine the defendant should he choose to testify that on November 28, 2016, he sought treatment at LSU Student Health Center for cuts on his hands. The medical record indicates the defendant reported he was injured when he tumbled down 3 steps carrying breakables on Sunday, and they've attached a copy from the suppression hearing. And then at the hearing on the motion to suppress, he agreed to stipulate that his hands were injured in an altercation with both parents. I don't think that that really is a 608 matter, but I do think the state can inquire of the defendant if he were to testify differently to any of these things about what he had said in the past as a prior inconsistent statement. So I don't think at this point I'm going to consider that proper 608B3, but I certainly suspect if he does testify, the state will be able, if he explains the injuries to his hands in some other way, then these could be used as prior inconsistent statement to impeach him at that point under 613, not 608B3. Number 2, the defendant was deceitful on intake when he characterized himself as a graduate professional degree student when he was in fact not enrolled in a graduate degree program. I do think that the state can, if they can show that is a specific instance of conduct where he's demonstrating deceitful behavior. I do think that his testimony, his credibility as a witness, should he choose to testify, would be highly relevant, and any instant where he's lying about his status around this time would be highly relevant to that credibility. And I do think that the probative value on that issue would outweigh any danger of unfair prejudice. So I would allow the state to inquire on number 2. Number 3, the defendant was untruthful when he testified at the suppression hearing that he was completely dependent on the LSU Student Health Care Center for medical records. Again, I don't think that that comes in under 608B3, but it is a proper avenue for cross-examination, and should he give a different answer, then I think that would open that testimony up to confrontation under 613 as a prior inconsistent statement. And lastly, the defendant was untruthful to Michael McCracken when he lied about his mother's occupation and status as a graduate student. I certainly think the state can ask him if, in fact, he told Mr. McCracken that his mom was an optometrist. So I don't not 100% sure that's 608B3, but if it is, I think it does. The probative value regarding his credibility does outweigh any danger of unfair prejudice. And so I think 2 and 3 are proper to inquire upon. 1 and 4, the areas are proper to inquire upon, but the actual statements at the suppression hearing, and I think they're both suppression hearing, will only be opened up should he give a different answer. Then it would be potentially 613 statement for a prior inconsistent statement. All right. So that's what I'm going to rule on that. Mr. Guy, what I want to do now is talk to you about your right to testify. I'm going to swear you in. You're going to remain seated there at the table. Your lawyer is going to ask you a few questions. Just make it clear on the record that you know this decision is completely yours. So if you please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, Mr. Halstead.
Mr. Guy, have we spoken to you about your right to testify?
Yes.
Have we discussed the pros and cons of that?
Yes.
Have we given you our opinion?
Yes.
Do you need any additional time to think about your decision?
No.
Do you feel like you've been given enough advice from us and your own thinking to make a decision?
Yes.
And have you made a decision?
Yes.
And what is that?
No.
All right, and you do understand, if you wanted to, regardless of what your attorneys advise you, that you certainly could. That decision is completely yours. You understand that, Mr. Guy?
Yes.
And so it's your decision, after being informed and discussing this with your attorneys, to not testify in this case. Is that correct?
That's correct.
All right, thank you, sir. All right, we also have a stipulation that I think we need to enter during the defense proof. Do we have any other proof, Mr. Halstead?
No, Your Honor.
All right, so what I would suggest we do is go ahead and have our instruction conference, then take a 30-minute break. When we come back, we'll do the defense proof through the stipulation and jump straight into closing arguments. All right, so let's take a look at instructions. I've emailed you one draft. I've been working on them this morning in a little bit more detail, and I'll send this to you in just a moment. All right, so the introduction is the same in every case. I want to skip to the first and second counts. I've put counts 1 and 2 together for first-degree premeditated murder. The only difference between these is that the alleged victim in count 1 is Joel M. Guy Sr., and as to count 2, it's Lisa Guy. We do have the definition that applies specifically to intentionally in first-degree murder here with element 2. The act was premeditated, and then the definition of premeditated. So any questions about counts 1 and 2? Counts 3, 4, and 5 I've separated just so it's not too confusing. Count 3 is first-degree felony murder during first-degree premeditated murder. This is the alleged victim is Miss Guy. The killing was committed in the perpetration of first-degree premeditated murder of Joel M. Guy Sr., and was closely connected to that homicide, and the defendant intended to commit the alleged first-degree murder. And so here I tell the jury regarding the first-degree premeditated murder of Joel M. Guy Sr., they're to look back at count 1. Again, the definition of intent refers back to count 1. Considerations of factors such as time, place, causation are helpful in determining whether it was in the course of the first-degree premeditated murder of Joel M. Guy. And then lastly, there's the definition of intended. All right, so any questions on count 3? Counts 4 and 5 I've put together. They are felony murder for theft. Again, I've actually changed the wording a little bit. It's still first-degree felony murder, but actually we know that theft doesn't have to be over $1,000 to be felony murder. So I've changed it, instead of saying the perpetration of felony, perpetration of theft, and then we define theft below here. So any questions on counts 4 and 5? All right. And counts 1 through 5 have the exact same lesser includeds, just 2 different victims. We've got the order of consideration instruction. Then I have second-degree murder first, Counts 1 and 4, the alleged victim is Mr. Guy. Counts 2, 3, and 5 is Miss Guy. Then I've defined knowingly for second-degree murder here, and then we've added the language, the distinction between voluntary manslaughter and second-degree murder with the second-degree murder instruction. Any questions on first, lesser, or second-degree murder? Well, yes. Yes. All right. Yeah, go ahead, Mr. Harwood.
And also, we believe instruction should be that state of passion is a defense to second-degree murder rather than an element of voluntary manslaughter.
All right. Thank you, sir. Yeah, this is a legal issue that has been litigated for years and still in the course of that. I'm going to show that the defense objects, as Mr. Harwell just outlined. I think this is the appropriate way to instruct it. I don't think it's a perfect answer, but I think it's the best that we can come up with at this point. So I'm going to overrule the objection, leave it the way it is. Next, I've got voluntary manslaughter. Again, the difference in counts 1 and 4, the alleged victim is Mr. Guy, and 2, 3, and 5 is Miss Guy. And then reckless homicide is next, with the definition of recklessly for reckless homicide there. And lastly, I have criminally negligent homicide with the definition of criminal negligence. So any questions at all regarding the lesser included offenses? All right. So now we turn to counts 6 and 7. The only difference between these two counts is which person we're talking about. Count 6, it's Mr. Guy. Count 7 is Miss Guy. Everything else stays the same. And then we have the definition of ordinary person. And then knowingly is defined in definitions. And there's no lessers for abusive corpse. All right, any questions on count 6 and 7? All right, definitions. I've added the general knowingly here because we have theft as an underlying offense for felony murder. So this will apply to that. Intentionally also would go to that. We have obtain, having to do with the theft, exercise control over property and owner, all having to do with theft, effective consent, and deprive. Every other definition's been included in the particular count. So any questions on the definition sections? Expert witnesses, I have Brad Park and Tom Finch as latent print examiners, Kim Lowe, serology and DNA analysis, Dr. Amy Halls in forensic pathology, and Dr. Marks in forensic anthropology. Any questions on experts? Next, I do have flight in here. This is the pattern flight instruction. Any questions or objections on flight? Okay.
It is true that Mr. Guy was not at the scene, but that doesn't mean that he had fled the scene. There was no proof as to that other than the fact that he wasn't there, that he had traveled back through Mississippi at one point, but there was no evidence that the scene had been discovered or that there was anything of that nature. So we do not believe that there's sufficient evidence of a flight.
All right, thank you.
Also, the record needs to reflect he went to his house. He was arrested at his house, so he wasn't, besides leaving the scene, there also has to be, a hiding out, a concealment within the community, leaving for parts unknown. The only way they found him was the only way you can find him, go to his house, and he was there. So we don't think flight is appropriate here.
All right. I say this every time when flight gets challenged. I think this is the best written instruction that we have in the pattern. And no, I didn't write it. But it's very clear to the jury explaining what flight is and what it isn't. And it also tells them that there can be completely innocent reasons for taking flight. And so I think it's not harmful at all, depending upon the circumstances of the case. I do think flight has been fairly raised by the evidence in this case. It's clear that the defendant was here in Knoxville at the time that these, or at least around the time that these offenses occurred, and then left. We have traveled in the middle of the night. And I understand Mr. Stevens' point that there's not strong proof about an evasion or hiding out, because it takes both a leaving the scene of difficulty and a subsequent hiding out. But he did leave several states away, and I know he was arrested outside of his apartment, but I still think there's enough evidence here that the juror could believe that he was fleeing the scene to avoid being captured there with the bodies. In light of the fact that there was an attempt to destroy these bodies and destroy the evidence, I certainly think flight goes hand in hand with that. So I'm going to overrule the objection and leave flight in there. Destruction of evidence, the state has requested that. Any objection to the inference on destruction of evidence? Yeah, take your time.
Your Honor, we object to the records to that instruction. I don't know that that is, it may logically be correct that a jury could infer that. There's certainly no reason for the court to be highlighting that or any statute or law requiring that be given. That's just something they will probably be thinking about, but I don't know we need an instruction on it.
Yeah, a lot of these inference instructions usually kind of go hand in hand with sort of common sense, and they're actually put in there because there are issues that frequently come up in criminal cases, and I think jurors sometimes struggle with, well, is that something we consider or not consider? So I agree with you, Mr. Harwell, on a lot that it really just kind of explains logic, but I think it's appropriate to go ahead and include it because I do think that the evidence that has been presented fairly raises the issue on whether or not there was an attempt to destroy evidence. We've got a notebook that pretty much says that there was an attempt to destroy evidence, so I certainly think the facts warrant it. Next, I've included the general identity pattern instruction. I want to point out something on this because I've made some changes, the changes that I always make in this case, because this instruction is required to be given anytime identity is an issue in the case, as it is in this case. And the problem that I have with it is it just focuses on identification testimony. And probably more times than not, we don't really have identification testimony, and that's the case here. We don't have an issue in identification testimony because we don't have any eyewitnesses to the crime. So I've slightly changed the wording in this, and here's what I've added. So if you look at where it says the state has a burden of proving identity beyond reasonable doubt, I've added this sentence: proof of identity may include identification testimony. And then I go right into the pattern. Because without that sentence, I think the jury is just thinking, where's the witness who's identifying who committed the acts? And so the second paragraph, or after the questions, the second paragraph, I've changed it a little bit as well, too. The first sentence, I think, is all the same, but this last sentence I've changed. I said, if after considering all the proof in the case, including any identification testimony, you have reasonable doubt the defendant is the person committing the crimes, you must find the defendant not guilty. So it's not terribly different than the pattern instruction, but I try to word it in a way that it does include language to allow the jury to look at something beyond identification testimony to prove identity. So any questions or objections to the identity instruction? No. All right. Prior statement of the defendant, we do have the call. I don't think it qualifies as an admission against interest, so I've just used the general prior statement of the defendant instruction. We've heard fingerprint evidence. I put the pattern fingerprint evidence instruction in there. There's an extra period.
Your Honor, just clarify on the admission against interest.
Okay.
Defendants to argue in closing a portion of that call. Mr. Guy asks Mr. McCracken, tell me what, based to the, something like, why did I do this? How could I do this? Tell me I'm an effing idiot. So we would submit to the court that it is an admission of guilt.
I understand your point, General, but what Mr. Guy, in the context of what he was saying to Mr. McCracken, these are questions that I'd be asking for you. Why aren't you, this is what you might be wanting to know. So I don't really think that, I'm going to let you argue that. I'm not going to tell you you can't argue it. But I don't think it rises to the level that I should instruct on admissions against interest. What does the defense think on that? Do you want the admissions against interest instruction or just this general statement instruction?
Just the general.
All right, I'm going to stick with that.
As long as we can argue it.
Yeah, I'll let you argue it. I mean, it's subject to different interpretations. That's part of why I'll let that part of the call in, because I think it's subject to that.
Satisfied with your instruction.
All right. And the rest of this is all the stuff that we always put in here. Admissibility of evidence, statements of attorneys, statements of the court, presumption of innocence, state's burden. I've defined reasonable doubt, taking notes, and this is the instruction telling them they have to decide what the proof shows, what they may consider. If we have any prior inconsistent statements, we'll take out testifying. I assume the defense does want the instruction on not testifying.
Yes.
All right. And then we have circumstantial and direct evidence instruction, unanimous verdict instruction, and don't talk to anybody about it instruction. And that's it. Any questions on the proposed jury instructions from the state? Anything else from the defense? All right. At the end of those, you will find the verdict forms. I've gone through these 3 or 4 times. You may want to go through them yourself because it's ones I always seem to make a mistake on. But we've got the first count, first-degree premeditated murder with Mr. Guy, and then all the options for lessers and not guilty. Count 2, first-degree premeditated murder with Lisa Guy. Count 3 is first-degree felony murder during the perpetration, first-degree premeditated murder of Joel M. Guy Sr. with the victim's name there. Count 4, theft for Mr. Guy. 5, theft for Miss Guy. 6 is abuse of corpus, Mr. Guy, no lessers. And lastly, 7, abuse of corpus for Lisa Guy. All right, are the instructions acceptable at this point for everybody? All right, I will, Mr. Halstead, you good with these? All right, I will go print these out. I will email them to you as well, too. It is now 10:48. I think it's too early to eat lunch, so I'd like to go ahead and start closing. We may not finish. I doubt we'll finish before lunch, but let's at least get it started. So let's say 11, how long do y'all need, General?
30 minutes.
All right. All right, 11:20. Is that good for y'all? All right, court stands in recess till 11:20. We'll hear defense proof and go into closing arguments. Court's in recess.